With respect to the FISA Court's activity, I know we're close on time, so a few points very briefly. First, there have been proposals to add institutional advocates and sort of an other side to the FISA Court proceedings. The former presiding judge of the FISA Court himself has said that those proposals would be both unnecessary and unproductive, and really get in the way. That's his language, unnecessary and unproductive. In other words, they really would get in the way of the FISA Court doing its business. The FISA Court is made up of regular federal district court judges who hear wiretap applications all the time, and they don't have another side that's present when they hear those in their district court capacity. And so the judges are quite capable of making decisions on their own. Another point, just going back to something that Jamil said earlier, is that with respect to the broader conversation about whether the laws that Congress has passed are appropriate, many of the issues that are currently on the table pertain to sort of what our Fourth Amendment rights are and whether we have an expectation of privacy and whether something that's called the third-party doctrine, which is that when we give records to a company, we don't have an expectation of privacy in them. Some of the current proposals want to change that construct on the national security side. The problem with that is that's how law enforcement works every single day, is on these principles, these historic Supreme Court principles regarding our expectation of privacy. And so we need to keep in mind that this conversation is really not just about the national security space. When we get into the constitutional precedents and the Supreme Court precedents, there really will be a meaningful impact on the law enforcement side. And what we don't want to do is end up again in a situation where the national security authorities are much more stringent, much more difficult to work in to protect the country than in regular law enforcement